Okay. We'll call the Board of Equalization meeting together. Ms. Richmond, please call the roll.
Chairman Runner,
Here.
Ms. Ma. Here. Mr. Horton,
Here.
Ms. Harkey, Ms. Dowers.
Here.
Okay, with a quorum present. Good morning, members and guests. And we're going to start with the Pledge of Allegiance. We're going to be led by Roland Kisher, who has been a security guard here at the headquarters for 2 years. Roland was born and raised in Fiji and came to the U.S. in 2010 with his wife. He became a citizen in 2015. Roland is busy, has a busy workday after his security shift ends at 2 o'clock. He heads to his second job at a gas station in Elk Grove in order to make a better life for he and his family. We asked him if he would lead us in the Pledge of Allegiance. He said he'd be honored to stand up for his nation, which has stood up for him. Roland, thank you. Let's all stand together.
I please the allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Thank you, Roland. And I'm going to follow up with you, right? Okay.
Thank you, sir.
I have a vacation planned in Fiji later.
Oh.
So I figure, a real tour guide would be pretty helpful. Ms. Richmond, first item, please.
Good morning, members. Our first item on this morning's agenda is item C, public hearing. Item C1, proposed amendments to property tax rule 51, agreements qualifying land for assessment as open space lands.
Mr. Moon, welcome.
Good morning. Morning, Chairman Runner, members of the board. My name is Richard Moon. I'm with the legal department, and I'm here to request that the board vote to adopt the proposed amendments to Rule 51, which is titled Agreements Qualifying Land for Assessment as Open Space Lands. And this rule sets forth requirements that a pre-1969 Williamson Act contract has to have to qualify for valuation as open space lands. And the amendments replace a reference to a repealed rule with a reference to the statute that was the basis for the repealed rule. Thank you.
Okay, members' question?
Yes, Mr. Runner.
Yes.
Thank you, Mr. Chair. Thank you for bringing this forward, and particularly bringing about clarification as it relates to the Williams Act and the legislation and so forth. How does this rule and other rules or guidance we provide affect the agricultural open space land transfers?
Well, this particular rule applies only to pre-1969 contracts, so it has a very limited scope. We did contact the Department of Conservation and some of the assessors, and we were able to find out that they do in fact exist, these pre-1969 contracts, but we were not able to get an idea of how many of them exist. And so we thought the prudent thing to do would be to go ahead and amend this rule just in case somebody were looking for that information.
What would happen if the heirs decided they didn't want to cancel their contract?
It would just go on.
Just continue?
Yeah, yes.
Okay. All right. Thank you.
Okay.
Thank you.
Other questions?
Do we have any public comments?
I have no public,
No.
no cards or anything for public comments.
No.
Member Stowers, you had a comment? Just checking.
Just checking, just
Okay.
verifying.
Well, Mr. Chair, that brings up a question. How do we, are we soliciting, notifying folks about the hearings?
Yeah, we do notify about the hearings. We publish a notice that goes out at least 45 days before this public hearing. Prior to that, we issue a version of the rules that's proposed that the public has the ability to comment on. And in this case, we did both of those things, and the only comment that we got back was a letter from the County of LA in support of the amendments.
So, Chief Counsel, when we said we do a public notice, who's on that list of public notice?
It goes on our website, and it's also sent out to those who've requested notification of any rule changes, things of that nature.
Is there any reach out to, thank you, any reach out to the media who might have a broader span, reaching out to the general public?
Generally, the media they monitor our websites. I know this particular item was on the CalTax newsletter, so it does get out. In this particular
But do we reach directly reach out to the media, not assuming that the media is monitoring our website, but are we doing some kind of contact to the various media outlets saying that we have this issue coming up, please reach out to the public? I know the controller's office, when we do our media outreach, we're not passive about it. We reach out to the media directly so they know what's going on. Are we doing that here?
I don't believe we're doing any kind of special reaching out on this particular rule, especially, but, yeah, so.
I think it would be in the service to this board to have a direct contact to the media outlets in general, not just for this issue, but all issues dealing with property tax and anything.
So the question, at least as I think I'm understanding it, is that right now, as we make an announcement about a rulemaking procedure in terms of our normal interested parties contacts that we would have and targeted issues out there, the media, and I'm not sure how sometimes to define that or who to reach out to exactly, but the point would be the media then ends up learning about it secondhand through either what's on the agenda or through one of these other agencies. Is that what the concern is?
Yes, because I think we should be more proactive with the media.
Let me just add, I mean, I don't have any issue with that. I think I think the more the better, and I don't have an issue. I just don't know how to define, how to reach out to the media. What is your thought in regards to how to target a group or?
I actually think that, thank you, Director Officer. Go ahead.
Dean Kennedy, Executive Director. Typically, on a project, let's say we were updating the vessel handbook, a general vessel, we announce it with our letter to assessors that there's over 3,000 subscribers, so that it's out there and it's posted. But we kind of go through and try to identify groups, affiliations that in the vessel community. So that's how we approach it. So like when we updated the agricultural handbook, we made sure we hit farm bureaus.
Okay.
Department of Agriculture. So we develop an interested parties list and send it out.
Yeah, on this particular matter, I understand what the Deputy Controller is saying, but on this particular matter, we've done an interested parties meeting that occurred on September 8th, 2016. I think my understanding is we try to be a little selective, if you will. This is more of a routine change. This was done just to kind of take out a reference that was repealed and put in a reference that was basically the law changed, the reference needed to be updated. This is more of an update, more routine in that manner. So we didn't go through anything specific. But in this case, we still did an interested parties meeting. If the Deputy Controller would like to share with me kind of the methodology that the State Controller's Office uses to reach out to media, I'd be more than happy to look at it and see if we can implement that for future rulemakings.
I will. I just think that everyone needs to be, I know, I respect, it's kind of for this particular issue, it's very a small universe, but I just want to make sure that the public is aware of the various changes that this board is adopting so that they can voice their opinion.
Well, and I think sometimes the challenge is that what we may see as a small adjustment may be very important to somebody else.
Exactly.
And then also, if it's not part of our regular procedure, then there is a decision in there to decide when it is appropriate to deal with the media and when it isn't. And I'm not sure that's a good, safe place to be either. So
Yeah, members, I don't
Mr.
know,
Horton.
Mr. Renner, I don't know if the media is the outlet in general, because it depends on whether or not it's newsworthy. In this case, the Williamson Act is a broad act, that affects a lot of people, and particularly those in rural California, more so than anyone else. And so when you begin to tweak with something, you all of a sudden develop interest that may actually be insightful as to other areas that may need some sort of adjustment, or even in this specific case as it relates to the individuals who this would apply to. And this is one of those issues that have kind of been the legislature's looked at it and dealt with it, and the board has looked at it and dealt with it. A number of individuals have come before the board and expressed concerns about it. And so, not necessarily with this specific change, but in general, how this would affect them. So,
Okay.
I too would encourage it.
Okay, so what we have, with the issue before us, we need to take a vote on, and then I think what we understand is that, through the discussion, is that Member Stowers will work with the staff in regards to develop some kind of a process, possibly, that we might want to think about in regards to broadening the communications in regards to the rulemaking process.
That's exactly, thank you.
Okay, okay, is there a motion?
Move adoption.
Second?
Second.
Okay. Any objection? Okay, motion passes.
Great, thank you.
Thank you.
Ms. Richmond, next item, please.
Our next item are Chief Council matters. Item G, rulemaking for Section 100 changes. Item G1, Property Tax Rule 301, definitions and general provisions.
Okay, Mr. Young's on his way.
So
Welcome.
what we have for you, board members, chair, board members, are fairly routine changes that are conforming, more along the lines of what I would consider conforming changes. In this particular case, what we are doing is, there was legislation that was passed in, I think, late last year, that basically allowed assessors' offices to establish multi-jurisdictional boards. In other words, they can have an assessment appeals board shared between several counties. So all this is doing is adding to the definition these multi-jurisdictional boards so that it's clear those are meant to be included as well. And Mr. Young can provide more details.
Yes. Hello, Chairman Renner and members of the board. My name is David Young, Chief of the County Assessed Property Taxes Division in the Property Tax Department. I bring before you today the proposed amendment to Property Tax Rule 301, definitions and general provisions as it relates to assessment appeals. The proposed changes update Rule 301 to make it consistent with the recent additions to the Revenue and Taxation Code made by Senate Bill 447. SB 447 authorizes county boards of supervisors of 2 or more counties to establish a multi-jurisdictional assessment appeals board to equalize the valuation of taxable property within each participating county. Property Tax Rule 301 implements, interprets, and makes specific certain Revenue and Taxation Code sections by providing definitions and general provisions for the rules governing property tax hearings by county boards of equalization and assessment appeals boards. Effective January 1, 2018, Sections 1750 through 1756 authorizes county boards of supervisors of 2 or more counties to establish a multi-jurisdictional assessment appeals board by the enactment of an ordinance in each participating county. These sections are effective until January 1st, 2028. Therefore, staff proposes to clarify Property Tax Rule 301, Subdivision C, that the term board, as used in Property Tax Rules 302 through 326, also include a multi-jurisdictional assessment appeals board, along with the boards of equalization and assessment appeals boards. Staff requests authorization to complete the Section 100 changes to Rule 301 to make the definition board consistent with the recent addition of Revenue Taxation Codes 1750 through 1756. I'm here to answer any questions you may have.
Okay, members, questions?
Mr. Chair.
Mr. Hort?
Thank you, Mr. Chair. Not as much of a question, although I do have some questions, is that as a result of this discussion, the assessors as well as some of the folks in the industry have expressed concerns about the continuity of the Assessor Appeals Board. Some are part-time, some are full-time, and although the membership is sort of defined by law, when you have these individuals working part-time and some full-time, and I know that this seeks to try to address that by allowing counties to get together and theoretically have them work on more issues, so therefore the value of their service or the the individuals who are there can be more engaging, I think, to that extent. In regards to these various boards that are established, what is the board doing in order to make sure that all of them are educated to the extent about the issues and the rules, and to the extent that we can, that there is some continuity and consistency in the application? And then the taxpayers who are having to go before these boards have expressed some concerns about trial de novo because they're faced with a situation if they go to court with the appeals board being a quasi-adjudicatory body, that the evidence is not reconsidered by the court. And so the decisions made by these appeals board all of a sudden in a judicial environment become extremely important and relevant. And so that kind of puts a burden on us, I believe, to make sure that the evidence process, the gathering of evidence, the disclosure process is as equitable and uniformly applied as possible. So what are your thoughts about trying to modify trying to bring in, not trial de novo necessarily, because I have some pause with that, but trying to assure that in the appeals process, that the evidence process is equitable, fair, and uniformly applied, and the way that they interpret the rules are. So.
Do you want to? Okay, I got it.
Mr. Lenhart's here, too.
Yes. The board actually has various self-study courses, educational material available on our website. And a lot of that stuff is applicable to the assessor's office, but a lot of it does cross over into the assessment appeals domain. So that stuff is available. We actually have an assessment appeals manual which provides very broad guidance on the whole assessment process and how it is to proceed. We are currently actually working on a project that deals a lot with the assessment issues that are being brought up by both taxpayers, their advocates, and the assessors. And with that project, we're hoping we would be able to issue some additional guidance as to how the assessment appeal process should go, and we would take a look at it in a broad sense and update, review our assessment appeals manual also too.
Do we verify that everyone has taken the course, or is it just on our website and there's no requirements? I know our requirement as a board is to ensure that they have this information and that they, that everyone is participating. I'm just curious, is there certification, verification, anything?
There is not for assessment appeals board members. There are for appraisers. There is continuing educational requirements and hours for them, but it is not the same for assessment appeals board.
Do we have a way of gathering information as to whether or not there's any concerns about the application by these assessment appeals board?
Well, we could reach out directly to the actual county clerks of the board and see how they administer their training, their education, their continuing education for their board members.
And if we receive a legal question in this regard, who do we submit that to?
It would depend. If it's a general application about the Assessment Appeals Board generally, that would be to my office as Chief Counsel for this board. If it's about a particular county's Assessment Appeals Board, my assumption would be that would be to their county counsel's office, because as I understand it, the Assessment Appeals Board are basically under the jurisdiction of the counties themselves. So.
Okay. All right. Thank you, Mr. Runner.
Yeah, I have a couple of other members. I have a couple of just questions. When we do the county assessment through to the assessor's offices that we rotate through,
Yes.
do we address or ask questions specifically in regards to the assessment appeals boards? Is that a part of our review at all?
Yes, it can be.
Okay.
Not in
It
every.
can be in the sense,
It can be in the sense that if there is a reason why we should look at it, it's not precluded from it, but in general, we have a limited amount of resources,
Right.
and time and whatnot, so it depends on which topics we look at, but it is part of the rotation.
yeah, I know this is a very specific issue before
Yes.
us, and quite frankly, one that I'm supportive of. I
Okay.
represent a lot of these little counties, and so
Right.
obviously there's a difference between if you're in LA County and you have 11 million people and you have multiple boards of
Right.
appeal at that point versus you got a county with, 2, 3, 4, 10,000 people in it.
Yeah.
And all of a sudden it becomes a much better, different process. So I think the law that was passed is trying to strike some help to those smaller counties at that point.
Yes.
I think there is room for a broader discussion, though,
Okay.
especially as we talk about the board here and our role in regards to kind of enhanced property tax, since we're more limited at this point. Maybe it is that we look harder at some of these things. And I think the appeals process that citizens have is a really important part of their rights. And so maybe part of our future discussions need to be, rather than saying, well, if it comes up in the audit, maybe an issue is it's fundamental to the audit, because it is an important path for taxpayers when they have a question or when they have an issue and they want to kind of find their way to some point of justice in that process for themselves. So anyhow, I think it's a good discussion. I think it's something that we probably need to continue to address. Okay, is there a motion on this?
Excuse me,
Oh, yes.
Mr. Chairman, it looks like we may have a speaker that I wasn't aware of.
I'm sorry.
I wasn't announced. Good morning, Mr. Chairman and honorable board members. Chuck Lenhart, Plymouth County Assessor and
Okay.
President of the California Assessors Association.
Okay, thank you.
I probably should have stepped forward at the last item, but the CAA has looked at the prior item and this item, and we feel that it's the appropriate thing to do, so we recommend that you go ahead and.
Okay, thank you. Thank you.
Mr. Runner?
Yes.
Can the association take a look at or share their thoughts about establishing regional boards where there are regions and that enables the cities and the counties to be able to afford to have full-time individuals on these boards, all of them, and enables the Board of Equalization to now get a better handle over any discrepancies or disopinions that may exist and kind of monitor that process. And in doing so, I think that we could probably come up with a way, members, to have some to create some consistency, if you will, in the evidence gathering, evidence evaluation, receipt of information, and that whole process that seems to be percolating out there among California taxpayers. They seem to be a little bit concerned about it, and as a result, more and more people are finding themselves in court, and the legal cost is starting to hit LA County, if you will. And so, your thoughts?
I will share my personal thoughts on that topic. I think that I was supportive of the legislation that created multi-jurisdictional assessment appeals boards from a rather small county, blessed not typically to have a lot of appeals. It's difficult to keep board members, up to speed on the rules, county council. I believe that board staff did offer training for assessment appeals board members in prior years, and I think that's a good thing. I think that if this issue is, I think there's room for the staff to take a look at the process. I think the Assessors Association would encourage that there be some training for assessment appeal board members. And I personally think there is value in having multi-jurisdictional assessment appeal boards, particularly in rural counties, because I think that it is going to probably provide for a higher level exposure on the assessment appeals topics. And I think it's going to also eliminate some potential conflicts that boards of supervisors have when they're looking at one of their constituents and trying to be objective in making a decision.
Yeah, I believe also it'll create a higher capacity, higher skill set among the members, not necessarily that the individuals themselves doesn't have that. It's that oftentimes when they're part-time, they can't invest the time necessary in order to take these classes. What are your thoughts about mandatory training for the members of the assessor? I mean, training and education is the only way you're going to have some uniformity in application. I mean,
Maybe I'll take the politically expedient route and agree with you.
okay, all right. And what would it take to our staff? What would it take in order to accomplish that?
You're talking legislative changes that would be necessary for that.
Okay.
Now,
Okay.
having said that, the local assessment appeals board process is governed by the Board of Supervisors.
Yeah, again, I think the separation.
That discussion is different from what the assessors may think about that topic.
Right.
And what boards of supervisors may think about that topic could potentially be different.
Yeah, I think it's a good reminder right now to remind us that the assessment appeals boards are through the Board of Supervisors, not through the state, not through the assessors. Because they're
correct.
basically appealing the decisions that were made by the assessor.
Correct.
Well,
So in that sense,
are the Board of Supervisors.
Huh?
The Assessment Appeal Board is the Board of Supervisors.
sometimes,
Often, in my county,
Sometimes.
it is.
sometimes, and,
But it
and,
doesn't need.
yeah, right, and I think that's, again, the
I'm not here to
issue
make
there.
disparaging comments about my Board of Supervisors. That's the point.
Right, yeah,
You
yeah.
know?
Okay, any other questions, thoughts? Is there a motion?
Move adoption.
Okay, second, and a second? Any objection? Okay, that passes.
Great, thank you.
Okay, let's see, Ms. Richmond, what is the next item?
Our next item is G2, Property Tax Rule 469, mining properties.
Again, good morning, Chair Runner and members of the Board of Equalization. This is another Section 100 change to Rule 469. Again, this is what I would consider more of a cleanup change. This is to make, basically, there was a repeal of Revenue and Tax Code 53.5. This has to do with mining facilities, in specific leach pads, tailing facilities, and settling ponds. And we have, before I steal staff members' thunder like I did for Mr. Young, I'm going to introduce Mr. McCarthy.
Yes.
Thank you.
McCarthy.
Okay.
Good
Ms.
morning.
McCarthy, please.
Yes, my name is James McCarthy. I'm the Senior Petroleum and Mining Appraisal Engineer at the Board of Equalization. And this amendment that we're presenting before you today is mainly to bring us back into compliance with the deletion of Section 53.5, which treated settling ponds, tailings facilities, and leach pads as separate units for measuring declines in value.
Any questions, members?
Mr. Chair, just an observation, if you will.
Important.
Thank you, Mr. Chair. This is good that we're doing this. The way it came about, though, is somewhat concerning as it relates to just the timing, that it probably should have happened sooner, and that the process is obsolete in itself. And so it causes me to pause a little bit and wonder if, in fact, we're taking a look at all of the industries that are under our jurisdiction and seeing if there is a change in technology, a change in, in practice that has rendered certain things obsolete. I know we rely on the taxpayers themselves to protect themselves if they think it's obsolete, to put forth that argument in the assessment process. But oftentimes, that ends up with additional debate and evaluation and assessment because we may just follow the law. You can say, well, thus says the law, and then that we need a legal change in order to address something that is just obsolete. And thank God for the assessors who are doing an exceptional job and are generally very flexible in that regard. But are we considering looking at the industry and trying to make that determination?
Mr. Horton, this particular section of the tax code was passed almost 20 years ago, and it was sponsored by a mining company
Right,
that felt that they were being treated unfairly on a particular appraisal.
right.
And since that time,
Because these
at least-
pools have, after they finish, they have, go ahead, I'm sorry. Paul.
well, the unintended consequence was that while they felt they were dealing with leach pads and settling ponds for
Right.
gold mining properties,
Right.
we have settling ponds and tailing facilities for just about every type of mining property in the state. It created an additional burden on the assessors, and actually since this thing has been passed, we've been recommending its repeal. When it was first passed, we did reach out to the industry and said, okay, how should we value these particular properties? And we got no response. We again asked a year later, how do we value these properties? No response. So it was kind of something that they pushed through, and then once it was pushed through, they abandoned it. And so we have been making recommendations, and it was only recently that we were able finally to find somebody to sponsor the legislation.
Are there other areas that you've observed a similar obsolete lesson?
Not with respect to statutes that we have to deal with. There are some other areas that I think we can make some changes to rules in the future, but it's not my place to bring those forward at this time.
Whose place is it? Is ours?
No, actually, it's Mr. Young's, and I provided him
There you go.
with the documentation for some of the things that that I feel that we should be looking at some point in the future, and I think he's just waiting for the proper time
Yes.
to bring it forward.
Yeah, board members, as you're aware, unfortunately, with the change or split of BOE, our staffing has been quite stretched. We are aware of a lot of these items, and we are trying to proactively look to things that need cleanup. The three items in front of you today are part of the effort to kind of clean things up and start getting on the right track.
Yeah, I want to hear from Mr.
Lenhart?
Lenhart.
But that you bring about another part of my concern is that operating based on a budget as opposed to based on a needs assessment, and I think at some point it would behoove us to make a needs-based assessment irrespective of our capacity, irrespective of our budget and so forth. I know the assessors would love additional budget in order to accomplish some of their objectives, and I believe they would be entitled to it, and that at some point, if they did a study, they'd be able to prove, in fact, the legislature as well as the county assessor, that additional funding would yield additional revenue for the counties in which they represent. But your thoughts on the issue?
First of all, I agree with you.
Hang on,
I think
okay.
assessors have done that analysis, and I think we have the information. The challenge is finding the funding sometimes to make it happen, though it appears in this budget season, there may be at least a limited amount of resources available for counties, again, through an extension of the SCAFAP program, which was a pilot the last 3 years.
Remember that, yeah.
When we talk about whose job it is to identify these areas where we need updates in the law, I think it's really a collaborative process between assessors and industry and board staff. I think all of us need to be aware of those areas where the law is not working, and I think we need to work together to find solutions to those things. And I think one of the things that really helped me a lot in the Great Recession was when the board published the manual on additional obsolescence for manufacturing facilities and in-utility adjustments, and I think that was a huge benefit to both assessors and industry. And so I think looking for those opportunities going forward is something that all of us need to be aware of.
Thank you, Mr. Runner.
Yes, I appreciate what Member Horton said. Yes, got it right. I just want to say that in today's time, that I really would like for the assessors, industry, agency staff to take a holistic view of our changing environment and how we currently apply our tax system, mainly property tax, and the environment that we're moving towards. Changing environment, climate change, automation, technology, and what we need to do to be ahead of the curve. And although this rule change is very important, it seems like we are behind the curve. and I really do challenge staff to be ahead, that we can look towards the future to decide how we need to change our property tax system to be current, effective, and efficient.
Thank you.
Okay. And I think the nature of these discussions this morning, I think, indicate that with a narrow view that this board has, it's going to end up with a greater inspection and concern in regards to the things that we are responsible for. And I think as we are going to hear from the executive director, I think it's going to be important then for us to continue to then make sure that the resources continue to flow in order for us to be able to have this more aggressive and appropriate role to make sure property tax laws and rules are clear for taxpayers and for counties and state.
Yeah.
Yeah.
Mr. Chair?
Yep. Yes, Mr. Hurd.
I would share, Mr. Chair, that it is actually part of a natural evolution that's taking place. As staff will probably share, is that the board has not looked at these matters in rules and policies and so forth, at least I would say dating back 30 years. I remember it was Claude Parrish and Dean Andel, somebody who kind of decided, and we started to look at it, and this collaboration took place between the assessors and the departments, and all of a sudden all these rules came up, and it was an exceptional good thing for the assessors and good for the department as well. And I think we learned a lot about what assessors do and the need for us to be able to provide the support in order for them to continue to do what they do. So I think it's part of a natural evolution. And then in addition, as we make this evolution, what's happening, at least for me is happening, is that some of my assessors are punting so I hear from my assessors a lot more than I've ever heard from them, and the taxpayers are calling, and so there's a greater interest now in all of these issues that's coming from the taxpayers, which would have come irrespective, I think, of the changes in the legislation. It's just that time of the session, of our history that this is happening.
Member Stowers.
Yes, thank you, Chair. Since we're talking about our future and property tax, I know in 2014, 2015, we really focused on embedded software, and I think it's a good opportunity for us to readdress that with respect to status SC. I know we have a good LTA on status SC, but I'm not really sure where we stand on the local side, so I really will like to challenge staff. Don't want to oversee my limit of directives, but I really want you guys to put together an issue paper on embedded software, because technology is where we're at, and we really need to have a strong foundation on how embedded software is being taxed or not being taxed.
If I may address Mr.
Very
Hurd's
quickly.
comment for a moment.
Sure.
When we talk about the budget issue, and this is the wrong time and place, but I think that we need to talk about budgets and salary ranges and competitiveness in the market so that we can ensure that you have the best staff available to address these issues.
It's a concern we have. Okay, is there a motion?
Move adoption.
Second.
A second? Without objection? Okay, thank you.
Thank you very much.
Ms. Richmond, the next item.
Our next item for today is item I, Other Chief Counsel Matters. I-1 is the resolution conferring powers on the Executive Director.
Okay, Mr. Ninja.
Yes, thank you very much, Chair Runner, members of the board. You have in front of you two documents marked Option A and Option B. Option A is a revised conferred powers document to confer powers onto our Executive Director. If you remember, back in January, we passed a lighter version of this, for lack of a better term, for Mr. Kinney. I was asked by Deputy Controller Stowers to kind of look into the gaps and whether or not this is consistent with the board's authority. I have done that. What Option A represents is an addition of two items, paragraphs A and B. And real quickly, there is a difference between authority and execution authority. And what these two provisions require, or what it turns out there was a gap in, is that a lot of our control agencies, Department of Finance, Department of General Services, are looking for a document which provides the authority for someone to sign for the agency as a whole, the Board of Equalization. With regards to letter A, those are for budgetary and fiscal documents. What this document does is it provides the explicit authority for Mr. Kinney, as your executive director, to execute those documents and bind the organization. With regards to letter B, that does the same thing for procurements and contracts. This is the same language, or very similar language to what existed before the split. What I was able to determine from our in discussions with our control agencies is they would be looking for this type of language to confirm that Mr. Kinney, in fact, has the execution authority over these documents. So that's what this revised conferred powers does. With regards to option B, I had received some input from some board members. There are basically two basic changes. One is in the second resolved paragraph, or what I would consider recital paragraph. There is an explicit reference to AB 102, AB 103, and AB 97 to acknowledge that there was a change in the board's authority and functioning after July 1st, 2017. The second change that was suggested or we were asked about was reducing the $1 million to $500,000 limit. So I present the input that I've received. I was asked to provide a recommendation. I actually would prefer to stay with option A because I think that is consistent with what this board has done in the past, and what I think it's a little more straightforward, but I don't have an objection to option B. So it's for the board to discuss and indicate your pleasure.
Member Mall.
Thank you. I actually would like option B. I think the authority should be decreased to $500,000. We've had problems before with the last administration going around the $1 million limitation and basically chopping contracts in half to get around that. And so I think it's more fiscally responsible and accountable for the board to see any contracts, over $500,000.
I kind of,
Member Sauer.
sure, I agree with Member Ma that the 500 limitation is reasonable for us to have the check and balance. And I also like the reference to AB 102 and the various changes that affected this board. I also want for the Chief Counsel to comment on, in January, I know I expressed some concerns about the initial conferring powers. So I see now that we do not have any reference to personnel matters.
Correct.
So it's my understanding that those powers from my favorite movie, King Arthur, were not our powers to give.
Correct. Thank you very much, Deputy Controller Stowers. That is correct. I have looked through those. Those were very clearly in the legislation left with Mr. Kinney and board staff. So, yes, agency staff. So a conferred power is not necessary along those lines.
And as far as the contracts, finance, DGS, and Department of Finance, have you actually spoken with those, and are they in agreement with the modifications as reflected in option B?
Yes, I've had conversations with individuals from DGS. I had some brief conversations with some colleagues over at Finance.
Have any of those conversations been documented in writing?
No, I do not believe so.
Mr. Horton?
Yeah.
Just from overall, from our operation, I would advise you to get all your conversations in writing.
Yes,
We tell our taxpayers to get it in writing, and you too should follow that suit.
Is that, I guess, and the purpose for that, as I would surmise, would be that then as we move forward with this, if there is some future objection, we've can demonstrate that we've had previous conversations and there's history to whatever got us to where we were.
Absolutely.
Okay, Mr.
Yeah, so
Horton?
even if our control agencies aren't willing to put it in writing, I would recommend that you put it in writing and document it to the file memo, something. When I was in the accounting firm, we always put something to the file, documenting what we said.
Yeah, that I have done. So I do have plenty of memos to file documenting the time and place of the, or time and
I
date of
assume
the
in writing,
conversation.
you don't mean a formal piece.
I don't mean a
You talk about
formal-
an email back and forth. that
Email
then
back
goes
and
in
forth,
the- yeah,
something
sure.
that you can
Yeah.
document so
Yeah.
that if it comes up,
Yeah.
that we can retrieve it. Maybe it's not this sitting board, but the board in the future can say, well, our chief counsel advised us on this.
Yep.
And I know by having this conversation today, it's going to be documented in our minutes.
Yes, and that is a point well taken, so I will definitely do that going forward. Thank you very much.
Member Horton?
Thank you, Mr. Chair. I mean, that's another reason why it's good to have these things come before the board instead of them, not just in general, as much information as we possibly can. And I'm supportive of option B for similar reasons. Part of the concerns, member, to be honest with you, was the legislation basically codifies the board's practice historically as far as conferring powers to the executive director having authority over personnel as well as the civil servants, CEAs, and so forth. Those authorities existed in the past, and the concern is that the conferring powers didn't necessarily make reference to the legislation. As a result, we ended up with a lot of false narratives about board members being able to have authority over civil servants, which we don't, as well as the termination of CEAs, which we have never had any authority over the history of the agency. So in order to, I know you can't control false narratives, but you can, to some extent, minimize them by bringing as much clarification as to who has those authorities and who doesn't. So with that, members, I move adoption of option.
There's a motion of option B.
Second.
There's a second. Yeah, I'm fine with option B. My only issue that I have to struggle with is that within the language is the title that they gave the bill.
Yes.
Taxpayer Transparency and Fairness Act.
Yeah, well, nothing.
I have my own questions as to whether or not that's true.
So
But since that is the legislation, I guess I'll have to live with it. Any objections?
We could just use the bill number, if you like.
That's fine. Any objections? Okay. Okay, that passes. Thank you.
Thank you very much.
Okay, next item on the agenda is, Mrs. Richmond.
Our next item is the administrative session. Item J is the consent agenda. J1 is the approval of board meeting minutes for the February 27, 2018 board meeting. And J2 is the report on time extensions for San Luis Obispo, Sierra, and Ventura counties to complete and submit fiscal year 2018-19 local assessment roll pursuant to R&T Code Section 155.
Okay, and these can be taken up together. Is there a motion?
Move J1 and J2.
Okay.
Second.
Second. All in favor? Oh, excuse me. Without objection? Okay, there you go. That passes. Ms. Richmond, next item.
So our next item is item K, other administrative matters. Item K1 is the executive director's report. K11, organizational update.
Mr. Kinney.
Good morning, Chairman Runner, board members. Dean Kinney, Executive Director. Today I'll make some brief comments. Hopefully we'll keep them brief. We'll see. We continue to work through the 9th month now of our split brought about by AB 102. Regarding facilities, as you're aware, AB 97 tasked with us to consolidate the board members into one state-owned facility. We're working with DGS on that. We thank them for their cooperation. When we have more to report on that, we will, but it's an ongoing process. Regarding our vacancies, we continue to process those as quickly as possible. We appreciate CDTFA's assistance since they administer our HR function, so that's going smoothly. And as far as the budget hearings, as you know, March, April, May, it's the budget season. We're into pre-hearings and the hearings that, as Ms. Fleming and I go forth on that effort. In the hearings, we'll be conveying our challenges, both as an agency and board members' offices, relative to our budgets and positions and the situation we find ourselves. And we'll be conveying our needs for adequate funding and staffing to perform our missions and constitutional functions as a board. That ends my presentation.
Okay. Questions, members? Member Horton.
Thank you, Chairman. Thank you, Mr. Kinney, for your presentation. In the budget process, I'm finding that over the last 8 months or so, quite a bit of service has not been made available to our office, and understandably so because of capacity issues. But as this budget process seems to evolve, I want to make sure that procedurally, institutionally, systemically, we're able to define what services are available for the fulfillment of the members' constitutional duties, and particularly prior to, for example, prior to the split, the member's office would receive legal services as it relates to Bagley King and a number of those different issues. They receive legal services as it relates to public records requests and just a number of things in that particular area. There was staff set aside in the legal department to the 3 staff members that would provide that type of technical assistance for the members to do their constitutional duties. The legislation also specifically says that the agency will not provide services as it relates to outreach and education. And so the question becomes, who's going to do, how does the outreach and education get done? How do we define who our taxpayers are relative to the Taxpayers' Bill of Rights? There seems to be some misunderstanding, but we've just gone through public hearings that suggest that our taxpayers are much broader than the assessors. And so how do we go about educating them? I appreciate placing it on the website, and so that those people who are interested can go and search. That's an after-effect sort of education that really doesn't serve to educate. It actually serves to reinforce if you want a place to go back and find information. But notification is probably the first step in trying to educate someone, because typically you're educating them because they don't know, not because they already know and they know which website to go to. So I guess what I'm getting at, members, is that I have not seen any quantification of what those services were and what the cost of those services relative to our constitutional duties and what services are going to be provided. In fact, the legislation says that the degree of those services is actually left up to the executive director to make that decision. And yet, I don't know, we have not been told what the process will be in order to request that those assistance. And at this point, I think I'm more concerned systemically, institutionally, and procedurally for the next board than I am, going forward, because we've been able to accomplish internally a lot more, take on the budget analysis and who doing our own internal budget analysis. Legislative, we're now called upon to do our own legislative analysis, legislative review, and so forth, which traditionally has been handled by the administrative team in servicing the taxpayers that we service. The presumption is, not the presumption, but the reality is that as elected officials, we're basically conduits. So the request for legislative changes is coming from our constituencies, which is the assessors, taxpayers who are being implemented, such as the calamity, the fire and floods that's happening throughout the state of California. We receive taxpayers, our calls, our assessors receive calls, and they're asking questions about their tax base and how they're going to be able to address those issues. So what are your thoughts, Mr. Kinney, about providing the board with some quantitative analysis as to what those services are and what the costs of those services were historically, at least the O&E and the operating services.
I think as we continue to work through the transition, we're capturing data, that comes in from the board members' offices to see what the demand for those services are and trying to identify if we have resources, if under the legislative changes we can provide the services. So we can go back and look at it.
Yeah,
But I think the legislation kind of redefined our world, as it were.
I don't know if it actually redefined our world, and to the extent that it did, I don't know what that definition is, and so I'm kind of relying on staff to say, here's the delineation that was provided in the legislation, which is not a bad idea to have that delineation, but I think we need to have some clarification as to what it is and what those services are, because the legislature's asking. The Department of Finance has sent us a series of questions. We've yet to find out whether or not who will be representing the members in the budget discussion and what data will be put forth, whether or not. So if I could, members, just sort of summarize this, because I see Ms. Fleming has come forth to kind of respond to that. Thank you.
Hopefully.
And I don't know if relying on what the members are asking for is sufficient, because as I shared earlier, I'm not asking. We've submitted a legislative package that the agency basically said they didn't have the capacity. One person in the legislative division, and so we came to the conclusion not to put that pressure on the agency and try to be respectful of what you guys are going through, and basically do it ourselves with the legislative staff and various advocates in order to move that forward. So, a definition as to what those services are based on the historical information, which I think is available, what the costs of the services were based on historical information and the legislation, and as it relates to our taxpayers, who is going to educate the taxpayers, and not from a budget perspective, but a needs-based perspective. We just need to make that call, and then you can say, well, we don't have the funding in order to do that, and would be important.
Comments?
No, I just
couple
wanted to be
questions.
available
Yeah.
should there be any additional questions.
Yeah.
Just for reference, however, members, Brenda Fleming, Chief Deputy for Board of Equalization, it's an honor to be here with you today. We're on the same page and looking at the historical perspective. As a part of preparing for the budget hearing process, a lot of what we're doing is looking at the previous structure, staffing levels, and budget structure for what we refer to as BOE 1.0, and then looking at the legislation to determine what BOE 2.0 is structured as and what the needs are, and identifying that gap. Through performing that gap analysis, it gives us an opportunity to see where the shorts are so that we can try to address that gap. We clearly have some services that we had before, especially specifically in the illegal area. To your comments, Mr. Horton, we had additional attorneys, and we've presented that to the pre-hearing discussions to let them know that there are some specific areas that we're going to be asking for. Specifically the administrative area and legal that we had before, to your point, where the members had services that were provided by that legal team, FPPC, PRAs, et cetera. The additional comment that we're providing to them indicates that while we are a smaller organization than we were previously, we had approximately just under 5,000 employees before. We now have a little over 200, but we're still a government agency. And so as a state of California entity, we are still responsible for providing not just services to the members, but to the citizens of the state. So what we want to focus on is where we've been shorted in those areas, in addition to acknowledging and informing and hopefully educating in the board and the hearing process that we have are served by constitutional officers, and there's certain responsibilities and duties as constitutional officers that you all have, and how do we make sure that we can provide those services to you. We are making the distinction between the staff that are in board offices and the duties and the functions that you serve, where they are complementary to each other, but there's also services and skill sets that you have as board electeds that we don't have as a bureaucratic agency. And so we want to just acknowledge what those distinctions are. So we have an opportunity to make sure that you're getting adequate staff, because if your work shifts over to us, we're not necessarily staffed or skilled in the quality of work that you're performing as electeds. So we're raising that to their attention so they can understand the distinction, and hopefully try to get additional funding where we're shorted for funding purposes. So where we don't always ask for PYs in the budget terms, sometimes additional funding allows us to get either temporary help or contracts, consultants, et cetera, to try to fill those holes.
Mr. Chair, if I
Overall,
may.
it's-
Go ahead, follow up.
Thank you, Ms. Fleming. I think there might be some wisdom in separating the fixed costs from the variable costs, because the presumption is that if you reduce the number of employees, somehow that reduces your fixed costs. And when you look at it from a space absorption perspective, that may be true. The land, the space, and so forth, fixtures and things of that nature. But duties and responsibilities from an administrative and O&E perspective doesn't really change. Those costs are fixed irrespective of the agency. There's a point of diminishing returns that will occur if you begin not to address those fixed costs. In the case of CDTFA, I would imagine that they're experiencing an increase in accounts receivable, decrease in compliance, and things of that nature just as a result of that. In our case, with the legislation specifically dealing with education and outreach, we've been advised that speakers are not available, that the postage comes out of the member's salary. And I'm not saying this is right or wrong. I'm just suggesting that we have some delineation and clarification so that everyone is aware of what it takes in order to service the constituencies. Publication, outreach, database. Members are now looked to have their own outreach database to manage their own IT and things of that nature, which is something that we didn't do before. The constituents continue to demand that of the agency, and state government can go a long time before before such things as Prop 13 pop up, But I think we ought to be out in front of it, and we ought to lean into it. And to some extent, I think that for me, I just need legal counsel or advice or administrative advice on what those duties and responsibilities were and what the cost associated with those, and whether or not those services will be continued to be provided to the taxpayer. And if not, we should clearly tell the taxpayer, don't expect any outreach and education, just expect to go searching on the website. That's what you're going to get. Or members don't expect legal counsel because we don't have the capacity. And when I say capacity, I'm not necessarily talking about just another attorney.
Right.
We were fortunate to be able to benefit from the economy of scale. So we had experts that the property tax division, the timber division, alcohol and insurance were able to rely on. That it's no longer there, no longer available. That capacity is minimized, and so we've got this huge learning curve that our staff is having to deal with and to address. And so we need numbers and facts that we can look at, and I would imagine everyone else is looking forward to it as well.
Member Stowers.
Thank you, Chair. Some of the comments that Member Horton commented on, as far as Bagley cleaning and public records requests, I really would like confirmation from staff here that those type of items are being looked at and resolved through our chief counsel.
Yes.
And that I know that some of these requests, especially when it comes to PRA, there is some overlap with CDTFA and even sometimes with my office, SCO.
Correct.
And there's coordination so that we can provide a timely response back to the public.
Timely and comprehensive information. You're
Great.
correct.
Appreciate
We want to
it.
be in compliance with the act itself.
Yeah.
That's correct.
Well,
Member Horton.
let me just share, Mr. Chair, if I may.
Oh.
The question was not that. I think overall, I haven't had any challenge with that. But overall, the question now becomes is that on the member's staff, is there adequate capacity to be able to evaluate the request? And I want to isolate it to this one issue, because I think under the area of legal, there's Bagley-King, there's Robert Rules of Orders, there's board proceedings and so forth, but I think all of them will fit into this same category, is that historically in the past, there were folks who sort of specialized in this, and that expertise was available to the member staff so that the member staff could have that intelligent conversation with the chief counsel about those issues. That staffing capacity is no longer available to the members, and that is a concern. It's a two-way conversation.
I agree with you, Member Horton, that in the past, we did have some really intelligent and smart individuals that was here, not just staffing the chief counsel at the time, but staffing us. And we do not have that at this time, but I really think that that's where we look to our chief counsel to build those relationships and ask those questions. And if we have to have the current, was it the memo of understanding or interagency agreement, where that chief counsel can speak to those in CDTFA that have that knowledge, so that we can continue to move forward with BOE 2.0. And what we learned in the past, we should not forget. We need to build on that. And then I was kind of moving on to taxpayer education and outreach. Our office really would like to see the taxpayer rights advocate, not just to be the person who responds to our constituent complaints, but really is out there actively and proactively educating our taxpayers. And as the four members to my left, you know, each of you guys represent distinct areas and distinct constituents. You guys should be able to communicate what your needs are to our TRA. And our TRA should be out there in the community. And that TRA should, through the agency, should be covering the calls for posters and PSAs. It should, I don't know why it should, long as it's an issue, an item within our Constitution, our, you know, basically property tax. If it's within property tax, then BOE, TRA should be out there educating our taxpayers.
I think though the core of what the problem is that trying to define who our taxpayers are. You're right. If this is a discussion amongst property tax issues, particularly around state assessed property tax issues, our TRA can engage, and certainly there's a role there. The question, though, is, and I think the conflict that we have, because I think it's a much grayer area than just asking the staff to go figure it out, is what about the calls we get in regards to sales tax? What about the calls we get in regards to income tax? Those are the calls that we end up having to deal with, and the issue of what is our role in regards to that aspect of education. Again, I think there was what was said on the floor of the legislature as these bills passed is not represented in what is the language of the bill. Because the floor of the legislature is very clear. Oh, the board is going to be, these taxpayer advocates have more time to deal with all these issues now because you're not doing appeals, you're not doing these other things. So the intent of the legislators when they voted for this was that we would have this broader ongoing education responsibility when it comes to taxpayers. The question then is, how do we do that? What are the tools that we used? I think Mr. Horton brought up some good points in regards to that. How do you then use what you used to have to do that? We don't have that any longer.
Right.
I went and met with the Director of Finance last 2 weeks ago or last week to kind of discuss that and say, hey, look, what I don't want the finance to do, and as we all know, finance is getting ready to issue a report in regards to board member staffing this week. And so what I wanted to make clear, and I think hopefully we did in the responses that we all made back to the Department of Finance, was don't just evaluate what we don't do anymore. Don't say, oh, you no longer do appeals, you no longer do these things, therefore you need this smaller staff. What I wanted to emphasize is what we used to have as resources to which we don't have anymore. For instance, if we're to do a taxpayer education seminar, We used to be able to call on BOE to go ahead and deal with the services, to deal with getting the folks there for us, to going and getting the facilities, working out the speakers, and we used to then use them as the tool to help us establish those programs, of which then we basically educated thousands of taxpayers throughout the state of California, not only on BOE issues, but on FTB issues. We had EDD there. Those things aren't happening anymore. And so the issue I wanted to leave with finance as they're making this report is, you need to understand, now that we are responsible for taxpayer education, as it said, as the legislators told us, we now need those resources within our offices because they're no longer available to us through the agencies. And I think that's the issue that I'm concerned about, and I think it's one that we're going to be wrestling with, I think, through this year. And as we deal with legislation budget committees coming up, I think those are the discussions that we're going to have to help define what that role is, because I think an important part of what we're going to be doing this year is we're actually defining the role for that next board. You know, for us elected to the board, we're not going to be here next year. You know, the controller's representative maybe, but we're not. And so I think one of the important roles we have is help define and shape what that looks like in the future. So I agree with the concept. I think that we're going to have to work hard, roll up our sleeves to figure it out. And I think we're going to be engaged with helping to define what that role is as we deal with constituents.
I agree with Chairman Runner.
Yes.
That it is a question, you know. Is it this board's responsibility, authority, to provide the education as it relates to sales tax or income tax?
That's what the legislator told us.
Yeah. They said taxpayer advocate. I don't think they defined what that advocate was. I know that many believe that as an elected official is all taxes. I don't have an opinion on that.
Yeah.
But I do think that the various agencies, CDTFA and FTB, EDD, to the extent that we step into that area, really do need to increase their education and outreach.
Right.
And I don't have an opinion on whether this body can provide FTB and CDTFA on direction on what they need to do, but they definitely should be listening to you all, because you guys are the ones with the boots on the ground and hearing what your constituents are saying.
Yeah, I don't think it's a matter of direction. I think it's a matter of teamwork.
Yeah, very good word.
Right.
Teamwork. We need to work together to making sure that all the California taxpayers and area issues are served and represented.
Yep. Member Horn.
Thank you, Mr. Chair. You know, I don't know that the taxpayer has an advocate anymore based on the legislation. I think their advocate is the, appointed director of these various different agencies, and I think the director is starting to experience that. And in time, unfortunately, what happens in government, they're a lot like our children. We put these structures in place and they just go around it, and we don't realize it until the plumbing breaks. All of a sudden we realize that they dropped something in the plumbing that they should not have dropped in the plumbing. And so I think that's pretty much what is happening, at least from the fraud and investigation and the underground economy is concerned. It is just thriving. I mean, the underground economy is going, wow. And so, but folks don't really realize that until they started what they're not getting, because they look at the glass as being half full instead of attempting to fill it up. And so I think that's the inherent challenge there. My concern is the duties and responsibilities that the board is within its jurisdiction, that we do define who our constituencies are. The interpretation that our constituencies are just assessors, I don't agree with that, and I don't think the taxpayers agree, and I don't think the assessors agree that our role is not to educate the assessors, educate the appeals board, educate and represent the associations, such as the the various associations that are overseeing, representing taxpayers. I think we have a much broader role, and when we narrow it, and if we are to narrow it, someone needs to define who is going to provide those services that because the assessor is not necessarily within the assessor's purview to educate, equalize, assure consistency. In fact, I believe the Taxpayers' Bill of Rights, actually, they call it the Taxpayers' Bill of Rights for that reason, as opposed to the Assessor's Bill of Rights, with no disrespect to the assessors, is that there are taxpayers that fall within our jurisdiction that we have a responsibility to. And if not, we just need to define that. We need to say that that's not the case, and we're not going to educate those folks. And here is how they're going to receive that education. We're not going to equalize. We're not going to measure their concerns. We're only going to measure their concerns via the assessors. And if so, then we need to say we're going to spend more time with the assessors. We're going to give them more power and authority and open up that line of communication. I'm really just looking for a definition, quantifying what is, and what's the fixed cost, what's the variable cost, and so forth. On the sales and use tax and income tax, I agree with the members that as existed in the past, we took a position of collaborating because of the economy of scale. It's much easier to advise one taxpayer about property tax, their exemptions, nonprofits, and so forth, and just have the other folks there to that benefit. So if that can occur under the law, fine, it should occur. If not, then a definition that says that's no longer the case. So from my perspective, I'm really looking for some clarity as to, what it is in that regard.
In one sense, I believe that we have the same role as any other elected official down the street. I mean, if some elected official down the street, a state senator or state assembly member, wanted to do a seminar for taxpayers and invite all those agencies to come together, they certainly have the ability to do that. The difference is that they have some specific access to resources and services that we don't have, that we end up having to deal with them ourselves within our own budgets. And I think that's the issues of clarity that we need to have. So I think all this is a useful conversation. I think it's not going to be the last time we try to work through this. And I would encourage members to go ahead and have these kind of conversations with staff, with legislators, with Department of Finance, as we begin to try to help hone down what that role is. Because I think one of the most important things we're going to do this year is to stake out the role for future boards. Was there a comment from the public?
I would just respond to Mr. Horton's comment a bit. I think all of us as elected officials have a responsibility to be advocates and educators to the public. I find it, as I perform my job at the local level, I tend to be more of an educator oftentimes, because people don't always know the rules. And so I think that's a big part of the role that we play. And I'm looking forward to working with Mrs. Thompson as we go forward as the TRA. I've had excellent opportunities to work with the TRA's office in the past. I find that they're an excellent resource for me as a small county assessor when I've got a taxpayer who is questioning what I'm telling them, and it's an opportunity to say, here, go talk to a third party that has no bias in this matter. And I think it's been very effective, and so I encourage you to continue with that program. I actually wasn't going to weigh in at this point, but Mrs. Thompson and I spoke recently, and I'm kind of here to be a resource when she provides her presentation.
Okay, thank you. I think we're going to,
Just going to be real quick. All right, thank you to the public and Ms. Thompson. I do agree that TRAs are very important resources, and I can really speak with confidence that the Franchise Tax Board TRA, Ms. Susan Maples, is still out there, still providing the small business seminars with respect to income tax, and she's doing an excellent job. And I can also state with confidence that she is more than willing to work with all the elected board members and to speak to whatever issues you may have and partner with you. And although we do not have a voice in CDTFA, I have been monitoring their pages, their website page, and they have continued with the education and outreach. And I'm pretty sure that
I monitored it too.
Maybe we should reach out to the officer of CDTFA more directly and see how we can partner with him.
Yeah, and again, they are doing seminars. They're doing workshops in the offices, sometimes not in the offices, but what they're not doing is that collaborative effort for taxpayers.
Right. Yeah.
And that's what I think we need to figure out.
Exactly, so maybe that's where
Yep.
maybe we can push
Yep.
that agency.
Yeah, in fact, and yes, thank you.
Well,
And
Mr.
and in that transition, maybe we ought to go to the report from the Taxpayer Advocate's
Well,
Office.
Mr. Renner,
Go ahead,
just
Mr.
got a
Horton
follow-up
first.
if I may. I do have like a specific request. I mean, specifically, I'd like to have some delineation and some description and some quantification of what the services are, who the taxpayers are, and so forth. I agree with Ms. Stallworth. I mean, we have had excellent support from the other agencies. The agencies that are not participating is CDTFA, and this agency has, because of capacity issues, or I don't know if it's just capacity or it's understanding of what their role and responsibility is and who their taxpayers are. I had heard that the taxpayers are the assessors, but the law and the government code, from my perspective, speaks differently as it relates to Taxpayers' Bill of Rights 5908 and 5906, I believe would be the references, but I can get specific if necessary, going from memory. And so, but we just need to sort of clarify that. I concur that as elected officials, we represent 9 million individuals that are calling us, and certainly now they're calling more, and I agree with the chairman's assessment that the collaboration isn't necessarily happening, which means the state is reverting back to the historical way of doing the outreach and education. Numerically, they're doing more outreach and education in my district than I did, but which is a good thing. But the collaboration isn't necessary there, and so they're not necessarily getting the same level of participation because the product that's being provided is not something that is holistic, and whether this agency does it or some other agency does it or the state makes a decision that is not going to get done. It's that the legislation said, well, we're just no longer going to do that. That's sufficient as well, because I don't want to be in a position of having discussions or making presentations or responding to folks and saying, well, we no longer, you have no elected representative in that area anymore. Call these people, call these people, call these people, and all of a sudden, I'm not being responsive and accountable to the constituents, which I personally think is a violation of our constitutional duties as we were elected. Now, going forward, what, the new perception of the taxpayers who make the vote for the upcoming members is a different thing.
My only observation would be that I don't believe this staff, our BOE staff, can define who our taxpayers are. I think, quite frankly, their taxpayers may be different than my taxpayers.
Well,
by definition.
I'm even interested in who their...
Right. I think they can answer who their taxpayers are. I think by definition, though, we are different. And that's where I think the rub is going to be in the future, and that is, how do we service the taxpayers that are not the BOE taxpayers, but are the taxpayers that call us about franchise tax issues, about sales tax issues? How do we service them as elected officials? I think that's going to be the crux of what we do. So I think it's a good discussion for us to put on a future agenda, for us to answer some of those questions. And I think some of it is going to be areas that I think the staff's going to have to stake out, but I think, quite frankly, some of it's going to be areas that we have to stake out. Member Ma?
Yeah, and I think many of the agencies do have a liaison where they can, help with constituent issues. And I don't know if that's you, Ms. Thompson, that we should be asking all of our constituent issues to or not, but I know Franchise Tax Board has a number of folks who are just dedicated to answering questions, so we have been going, and using that unit, but it's just something to think about.
Okay.
I would throw out the idea of just an environment of customer service. Your role has changed a lot. Many of the programs that you previously administered have gone away. The calls are still coming, and some of that may be TRAs and multiple agencies having a discussion and finding out how to make referrals to the right place.
Yeah. Yeah, thank you. And the challenge I have sometimes with TRAs are good at oftentimes dealing with a problem issue. Once a problem occurs, sometimes they just don't have the time to be proactive in regards to upcoming issues. Okay, let's have a report from our Taxpayer Advocate's Office.
Honorable board members, my name is Lisa Thompson, Taxpayer Rights Advocate for the Board of Equalization. I'm here to present the 2016-17 Property and Business Tax Annual Report. The report is issued in accordance with the Morgan Taxpayer Bill of Rights, specifically Revenue and Taxation Code Section 5904. The report highlights the Taxpayer Rights Advocate accomplishments, involvement in projects, current issues, and examples of cases illustrating the services the office provided. There were 286 new property tax cases in fiscal year 16-17 compared to 169 in the prior year, a 69% increase. Of the property tax cases in this annual report, 64% of them pertain to valuation issues such as value reductions, change in ownership, exclusions from reassessment, and exemptions. 36% were in the administrative category, such as creating and mailing tax bills and refunds, waiving penalties, and public access to data. The largest source of referrals of the property tax caseload was from county assessors and the board's website. The next largest percentage was from publications. In addition to property tax cases, the Taxpayer Rights Advocate Office answered approximately 400 calls per month, addressing both property tax and business tax issues. These calls do not result in cases because they're quickly answered, or they might be referring taxpayers back to the assessor's office because they hadn't made an initial attempt to resolve them with their office. The two primary functions of the TRA office are to ensure fair and equitable treatment of taxpayers in the assessment and collections of taxes, and to recommend changes in policies and laws to improve and ease taxpayer complaints. Example of such change during fiscal year 2016 was when the Taxpayer Rights Advocate Office worked with the Board of Equalization's Property Department and Legal Department, resolving a matter where a base year value transfer exclusion was denied from an assessor's office. The result was a legal opinion being issued where they determined that, well, the exclusion required purchase of the land be purchased at the time of the replacement dwelling. In this case, the land didn't have to be 100% purchased. It was to be allowed. Essentially, 1/3 of the land was inherited from the person's parent, and the other 2/3 was purchased from the siblings. So as a result of this opinion, the assessor gave the taxpayer the base year value transfer exclusion. But before I address any questions that you may have, I wanted to point out some of the things that the Taxpayer Rights Advocate has done as far as since my appointment in January. I've worked with the web services team to update the web pages for the Taxpayer Rights Advocate, and they were placed into service this past Friday. The pages basically include the new phone number of our Taxpayer Rights Advocate Office, new MIC code mailing address, and then to identify me as the advocate. Also, there has been a simplified web form added to the website where taxpayers can ask questions or submit suggestions or comments directly to our office via automated email. The pages have been reformatted so they're easier to navigate, more taxpayer friendly. We have also added contacts to other Taxpayer Rights Advocate offices for state agencies as well as the IRS in case our constituents need those contacts for their assistance as well. At the last board meeting, members indicated they were interested in knowing about some of the educational endeavors that the TRA office had planned to do. And as part of the Morgan Taxpayer Bill of Rights, the advocate shall review and report on the adequacy of existing procedures or need for additional procedures as to the development and implementation of educational and informational programs on property tax matters, and also development of written materials that explain in simple, non-technical language various property tax matters. Code Section 5908 says that upon the request of a county assessor or assessors, the advocate, in conjunction with other programs of the board, shall assist assessors in their efforts to provide education and instructions to their staff and local taxpayers for the purpose of promoting taxpayer understanding and compliance with property tax laws. Earlier this morning, Ms. Stowers had brought up how we could look at new ways to be, I guess, more effective and efficient. And Horton had indicated, asked about what services we would be providing to taxpayers. So I do plan to leverage technology to educate taxpayers. Well, the Board of Equalization does have a lot of good resources on the website currently. I do think that there's a benefit to develop some short and easy to understand pamphlets or flyers on certain topics where taxpayers can go to find some basic information. Videos will also be a method. I think the website is a way to embrace technology. It's also a way to provide simple online resources which reach a broad audience and is available on demand at any time. So again, the focus will be simple, non-technical, because there's good resources again, but there's it can be simpler where we can direct taxpayers to read additional information, but to get kind of the basics ahead of time. The executive director, Dean Kenny, and I have talked about how best identify topics that would be good to create some flyers or short pamphlets. And so my office, as well as the property tax department, is going through past inquiries that we have had to identify areas where taxpayers could benefit from some guidance in simple, non-technical terms. And once those areas are identified, then we will develop a plan on how to create and publish that material. In addition to some short, easy-to-understand pamphlets, I think there is a need to publish some additional publications in the area of nonprofit organizations. One is to develop a publication on property tax exemptions available for nonprofit organizations, and then kind of a secondary publication to address low-income housing and the welfare exemption. So that will be on the TRA's plan the remaining year. I also plan to engage assessors in discussion on what areas they see as their taxpayers and constituents could benefit from with the board developing some educational materials for their constituents. And I will be attending the Assessors Association conference next month, where Chuck will be in attendance, and we will seek assistance or input from assessors at that time. One area I did want to talk about and seek your assistance or comment is on the Taxpayer Bill of Rights hearing that we will have. So in accordance with the Morgan Taxpayer Bill of Rights, it indicates that the board shall conduct a public hearing soliciting input from assessors, other local agency representative, and taxpayers to address the advocate's annual report and to identify a means to correct any problem identified in that report. The law requires one hearing, but in past years there has been two hearings, one in Sacramento and another in Southern California. Now that CDTFA is responsible for the business tax portion, it may not be cost-effective to hold hearings in both locations, given the fact that last year there were no property tax speakers in Southern California, and in the prior year there was only one. But you may want to discuss that. I do think the TRA's office, though, works during the entire year to resolve taxpayer problems, and so that's not the first time we've heard about it. So I think that's probably a reason for some low attendance.
Okay. Comments from the public?
Just here's a resource.
Okay. Yeah. Mr. Horton.
Ms. Thompson, I think you've done an awesome job. I mean, considering your staffing level, that's quite a bit of work. So I commend you for that. Section 5901 also speaks to the dissemination of information to taxpayers, and the Taxpayers' Bill of Rights clearly delineates three different groups. One, the assessors, other organizations, and taxpayers. How are we defining taxpayers in our efforts to reach out to them?
Well, yeah, I think there is a different audience for taxpayers, maybe of the board, Board of Equalization as an agency versus local assessors. So the TRA office does have to balance that. My focus initially would be more on the constituents and taxpayers of local county assessors in what they're doing as far as local property tax matters. And although some of that will touch on the board's program, so as far as information to nonprofit organizations, the Board of Equalization does have a joint role in the welfare exemption and veterans organization exemptions that it's jointly administered, where the board is responsible for issuing organizational clearance certificates to qualifying organizations before they are able to receive exemption at the local level. So that kind of will touch both, but I think developing a plan, to reach both audiences.
So you spoke of basically, I think, three categories, I think. The veterans organizations, nonprofit organization, and taxpayers that engage with the assessors are viewed, and to some degree, they're viewed as the taxpayers of the Board of Equalization as an agency?
Yeah, so as far as the Board of Equalizations, we have certain audience or taxpayers in regards to the welfare exemption and veterans organization exemption. So the welfare exemption, which is for charitable, religious, scientific, and hospital organizations, that exemption from property tax, well, a county assessor's office is solely responsible for reviewing the exemption claim on a location of that organization. The law requires that the Board of Equalization the organization must hold an organizational clearance certificate that's issued by the Board of Equalization before the assessor can actually grant exemption to that organization's property. So some of the information that the TRA office plans to issue and develop will kind of address both. So
you see it as a shared responsibility? Would I be?
Yes.
Okay. 5906 also requires that we identify areas of reoccurring conflicts between the taxpayers and the assessors.
Mm-hmm.
Any proactive effort, or we're just waiting for for them to come our way?
So I think the one way, is we have the resources that are on the website advising taxpayers to avail themselves of the taxpayer rights advocate. They have been revamped, so in my opinion, the web form is it's designed better to facilitate that. So if a constituent or a taxpayer at a local level or a taxpayer has a concern with the Board of Equalization's program, which is now primarily property taxes, then they can reach out to the advocate's office. So we have that in addition to the website. There is a publication that CDTFA now has that it identifies all of the taxpayer rights advocates in the state. So that publication will be revised to include my name and my contact information as to the agency's TRA. So that will be included in that. I also intend to reach out to GoBiz and see if there's some information on their website. All of the taxpayer rights advocates will be meeting at the end of April to talk about that, so I can certainly bring that up to them.
Let me share, if I can, is that in California there are approximately 8 million individuals that are living in poverty, and that there's a huge digital divide that exists, and there's a huge tax gap that exists as well. And so, unfortunately, they don't necessarily have the funding. Many of them don't have access to webs and this information and knowledge as well. The other challenge that exists in the middle income group, historically, studies have shown, is the lack of the expertise and professional services that will generally direct you to this information. It's the accountants and the CPAs that are made aware of it. And I'll share a story that I experienced when I was in the legislature. One year, we passed, I think it was 3,600 pieces of legislation. And so came on the radio that the legislature passed 3,600 pieces of legislation. And my son said, dang, how are we to know what the law says? And automatically I said, well, it's on the website. And he said, what website? And where do you find all of this? And so forth. And I think many of our taxpayers are experiencing the same thing. And I appreciate the financial decisions not to provide proactive education to certain constituencies that won't be able to access the web or won't have the professional support to know how to access the web. But at some point, let us make sure that we give consideration to those individuals as well and how they're going to be educated. I think it's financially expedient. There's a huge compliance issue there to enhance compliance, enhance benefit. As you know, I'm a fan of the earned income tax credit, yet despite all the information on the web, despite all the outreach, $1.8 billion in refunds goes unclaimed. The manufacturer's tax credit, I think it was somewhere around $187 million went unclaimed. And many of the folks have attributed that to, well, didn't know it exists. Well, it's on the website. So let me encourage that we kind of look at that in our role of assessing conflicts and providing fairness and equalizing things.
Well, I'm happy to look at different agencies and reach out to them where they could maybe be able to post a flyer that the TRA office develops. So different city and county agencies that may not be accessible to
Posting
website.
for them is kind of like the problem. Posting is not sufficient to be able to get the word out there.
Member Stowers.
Thank you, Chair. Great. Thank you, Ms. Thompson. I thought I had 4 points, but now I may have 5. I may have 6. EITC, yes, it's generally underserved. It's not your area of expertise. I understand that. But for the record, EITC California, Cal EITC, up 70% this year, mainly because of franchise tax board proactive marketing of the credit, the increase of the income threshold, and allowing self-employment. So I would like to say I do believe it's working. No, we're not getting 100% of that group, but considering that we've only had it for 3 years, you can definitely see the improvement in that utilization of that credit. Let's not dismiss it. With respect to our areas, let's see. One, you talked about outreach and our taxpayers. I will really encourage BOE, Taxpayer Rights Advocate, to reach out to various business associations like the Chamber of Commerce so that you can have your hands-on a direct contact with our taxpayers. 2, taxpayer assistance, tax appeals assistance program. Do you have any plans to continue the program? Under the prior administration, we had TAP, and TAP kind of represented all taxpayers: income tax, sales tax, property tax. And I'm just curious on what we're going to do for the property tax area. I know that next fiscal year, the franchise tax board is going to pick up the TAP program for income tax, and I'm assuming that CDTFA is going to continue it for sales tax. I think there's a service and a need for our office, our organization, to continue it for property tax. So just put that on your agenda.
Okay, thank you.
If you like. I noticed your report included property and business tax, and I'm assuming there was a collaboration because the split mid-year?
This is 16-17 fiscal year, so it ended at the end of June. So it did address both. I just gave statistics for the property tax portion of it here, but the report addresses both property and special taxes, because during that fiscal year, that was the audience that it served. So this report was issued and developed by the former taxpayer rights advocate, Todd Gilman, at CDTFA.
So next year will just be your report?
Right, it will just be my report with the property tax side of it.
You commented about, for the board to consider whether we should have 2 TRA hearings, because we generally, prior BOA 1.0 had 2 hearings. I would encourage you as the advocate to reach out to the other agencies, Franchise Tax Board and CDTFA, to see when they're having their hearings and see if you can be on their agenda. That way we can minimize the cost.
Sure.
But property tax issues could be addressed. Generally speaking, when we have those hearings, whether it's property tax or income tax or sales tax, the members do not respond. We just take it all in, and it's up for the advocate to respond and share with us. So I think that if you're at those various agencies' hearings, that you can really have your hand on what people are saying that relate to property tax.
Okay, and I did reach out to CDTFA already. They will be holding just one hearing for
Do you
their
know when their
portion
hearing's
of
going
it.
to take place?
No, they were just deciding that today, but it would be here in Sacramento. But historically, I mean, the taxpayer rights hearings are done at a board meeting, so they, I don't know if they would end up doing it on the same exact day here in
Just to clarify,
Sacramento.
so they are doing, for all their taxpayers, they're just doing one in Sacramento?
That's correct. The
Thank you.
business tax.
Wow.
The franchise tax board, taxpayer rights hearing traditionally takes place in December. I will
in
encourage,
this-
it's definitely
It's
December.
in the summer, the
It's
taxpayer rights
December.
hearing.
The hearing's in December, trust me. So I would encourage you to reach out to Suba Maples on,
Oh,
see if you can
FTB,
be
I'm sorry.
on her calendar, and I'm sure that she will accommodate any property tax hearings. So perhaps we can have ours in the summer, and then another one 6 months later that we can, I know they're both in Sacramento.
Oh.
I mean, or maybe we can do ours in another location.
Just an interesting issue, because I mean, my experience with taxpayer advocates, public hearings it's been with us, but you're right. We don't need to be there. The taxpayer advocate office can have their own hearings at that point. So what you're suggesting is the potential of having additional ones that we would not participate in, but that they would do, particularly maybe if they were located in other locations?
I think so. I mean, I know for the BOE, we've always kind of managed that process. But for the Franchise Tax Board, their hearing take place after the normal 3-member board hearing, but the advocate runs that hearing. And the members are there, and they have an opportunity to hear what taxpayers are saying, and of course, have comments.
Well, I think the last one that the new agency had was actually done by the taxpayer advocate down in L.A.
It wasn't. We were in our own meeting. and
We were in our
couldn't
own meeting at that
participate.
point, so they were having their own.
Which created
Yeah,
which
right.
an issue.
Yep.
So I really think it should be open. I mean, I really would like for it to be a date where all parties
I think
can
it's,
participate.
I think it's a good suggestion and a direction for the taxpayer advocate's office to do, to go ahead and review where other agencies are having taxpayer advocate hearings, especially if they're not in this area, to see if we can also be represented there to deal with taxpayer issue, property tax issues at those locations.
So, point of clarification, Mr. Chair, there's no legal requirement that the members hear the concerns of the taxpayers?
Well, there's the one, he can elaborate, but 5906D requires that the board, it says the board shall annually conduct a public hearing soliciting the input of assessors, local agency representative, and taxpayers to address the advocate's annual report pursuant to 5904 and identify a means to correct any problems identified in that report. So it's one hearing. So there would have to be, in my opinion, it has to hold a public hearing, so it would have to be before this board, but I can work with the chief counsel to see if we could
Well,
hold another.
what allowed them to have their own, I guess there was
I don't
no
think
board, so
I don't
it's
think they-
emergency regs or something that?
So in.
Okay.
We have a
Manager.
little bit, as I understand it, the hearing has to be in front of this board, but you're only required to have one hearing.
Well-
However, to the extent that, and I think the other agencies use the term hearing a little bit loosely. They don't have a board that oversees them, so therefore they are free to have hearings wherever they want or however they want. In our case, what we can do, and I'll look into the statutes a little bit more, but I'm pretty sure what we can do is, to the extent that we have our TRA attending those hearings and talking to taxpayers and what have you, and developing those issues, they can do that. It wouldn't be a hearing for our purposes, but it'd be more of a meeting where our TRA is available and could work with the taxpayers. If that's something that the TRA ultimately determines that they can't work out or needs to be heard in front of this board, then they can invite the taxpayer to the public hearing that's held once a year here in Sacramento, and the taxpayer could either come up, or it's perfectly reasonable for the taxpayer rights advocate to present their arguments for the taxpayer, and this board can still have this hearing. So this is something that we can work through.
Well, and it's also possible, if that was the case, and a TRA ran into somebody who was having a property tax issue, they could also make referral back to that board member's office for assistance in that process, too.
Absolutely, absolutely.
So there might be an interesting middle ground there, and I think it would be a good issue of research that I would certainly be supportive of.
Another point of clarification from a legal perspective, and again, because we're sort of, this is real time, I haven't had a chance to go back and look, but my understanding was that there was an interpretation of the law as it relates to a local hearing. It didn't say one hearing, it simply says a local hearing, and so therefore the interpretation was, how do you localize this process? Because it was more of a concern about participation, and particularly given the geographical restrictions that exist in the state of California, one of the largest land masses, aside from Texas and so forth, created inherent challenges, and particularly in more rural California, in being able to attend these things. So maybe I'll see if I can find a legal opinion, or maybe you can take another look at it and just report back to us what the interpretation was when they said a local hearing. The intent, of course, was to make sure that every taxpayer had an opportunity to express themselves through this process.
Okay, I think Mrs.
Just
Bowers was
one
still
comment,
working.
and I'm going
Yep.
to wrap it up. Thank you, Chair. I was thinking still having our own hearing here, but just piggybacking on
Right.
other agencies.
I think that's
Yeah.
the
And
understanding.
then final, with all this conversation and our earlier conversation, and this is really for those to my left and not to our advocate here, perhaps we need a statewide taxpayer rights advocate that cover all of our tax issues, income tax, sales tax, property tax, EDD. And I know that you guys have the influence and the power to look into that.
We did so well with the legislation last year.
I have faith.
Exactly.
Okay, thank you. Any other questions? Okay, thank you very much.
Thank you.
What's the next item on our agenda?
Our next item is K13, approval of the board meeting date change for December.
Okay, we have an item before us to change the date from December 11th to December 12th. Is there a motion?
Million uncollected.
Second.
There's a motion, right?
Yeah.
There's a motion. Horton made a motion.
Second. The motion is a second.
Ma made a second.
Whatever you say.
No, without objection? Okay. Let's see, we have no items, excuse
Could
me.
I just, not to
Yes.
to start up the prior conversation again with outreach and education stuff, I just wanted to put forth that, I don't know if you're aware that Mr. Gilman, the taxpayer rights advocate for CDTFA, he did provide a letter to all the legislators that when they're contacted by constituents, that they should direct them to him, and then he'll make sure that they get to the proper program people within CDTFA. So
That was-
he has put that forth. And when we're contacted by people with it at our level, we push them off to Mr. Gilman as well. So I just wanted to make that public statement.
Well, good, thank you.
Smart guy.
Okay. We have on schedule closed session, but I don't believe we have any items in closed session,
Correct.
correct?
Members, let me just express publicly, I don't need to go in closed session, is that I remain concerned about the education of our staff and notify them. There's a lot of confusion out there as to what their rights are and where they are in the process. And the lack of information to them is destabilizing their lives. And it's very uncomfortable. Many of the assessors that now represent, that we now represent, have concerns about whether or not the parity issue as far as their salary parity, where that issue is, and so forth. Not under my jurisdiction, but certainly let me encourage that we take a level of leadership to provide the staff with some information as to how these changes affect them in their personal lives.
Okay, okay. And with that, we will adjourn today's meeting, this month's meeting.
There's a